Section 3 of Tribal Custom in Anglo-Saxon Law by Frederic Seebohm. This LibriVox recording is in the public domain. Chapter 2. The Summary of the Cymric Evidence. Part 1. The Unit of Cymric Tribal Society. The next step in this inquiry will be to give a brief summary of the results of the evidence contained in the volume on the tribal system in Wales, adding at the same time such further details as may be useful in helping us to realize the methods by which tribal custom worked itself out in practice. Footnote: for the references to the codes and extents, and authorities for the statements in this summary, the reader must be referred to the former volume, but for additional statements full references will be given. Where not otherwise stated, the figures refer to the 2 volumes of Ancient Laws of Wales. End of footnote. The chief fact revealed by the examination of the extents and surveys of different parts of Wales made after the English conquest, taken together with the Cymric codes, was that the unit of society and of land occupation under Cymric tribal custom was not the individual and not the immediate family, but the group of kindred known as the wely or gwely. Such and such a velata or district is described in the surveys as in the occupation of the gwellies of so and so, the Latin word used for gwelly being lectus or bed. The form of society thus revealed was patriarchal, in the sense that the common ancestor, generally conceived to be the great-grandfather, during his life, and even after his death, was regarded as the head of the gwelly or group of his descendants for 3 generations. In his name, as its head, this family group occupied land and had grazing rights over certain districts, sometimes alone, more often in common with other family groups. As to what is meant by land ownership in the full modern sense, the question may not have arisen, or it might have come in gradually sooner or later, as agriculture came more and more into prominence. What property, strictly speaking, the tribesmen owned consisted mainly of herds of cattle. Naturally, therefore, what rights over land they may have had were mainly rights of occupation and grazing in certain districts for their herds. Their agriculture was secondary, and consisted of the right to plough up such portions of the waste or common pasture as year by year might be required for their corn crop. All that need be said at this moment about their agriculture is that it was an open field husbandry, the result of the co-ploughing of a common plough team, normally of 8 oxen, the joint contribution of several tribesmen. Returning to the gwelly, we find that when a child was born into it, whether boy or girl, it was formally acknowledged by the kindred. It remained at the father's platter to a certain age, generally 14, and then the father ceased to be responsible. The boy at 14 became the man and kin of the chieftain of the family group, or it might be of the higher kindred embracing several of the gwellies. From that moment the boy obtained by kin and descent a tribesman's right of maintenance. That is to say, he received from the chieftain his da, probably in the form of an allotment of cattle, and with it the right to join in the co-ploughing of the waste. Footnote: Professor Rees informs me that da in Carnarvonshire local dialect still means cattle, while in other parts of Wales it has the wider meaning of goods. The allotment of cattle involved grazing rights and often separate homesteads. Accordingly, in the Denbigh extent, we find that so-and-so habet domum, or non-habet domum. This dependence for maintenance of the boy upon the higher chieftain is indirectly confirmed by the extents, which mention, among the chieftain's rights, the fosterage of youths. That the chieftain who gives the da was the chief of kindred, and not a mere territorial lord, is shown by the fact that when a stranger family have lived in the land till they have formed a kindred by intermarriage with Cymres, all the members of the family become man and kin to the chief of kindred of the new kindred. End of footnote. He became thus a tribesman on his own hook, apart from his father, so that the unit of society was not simply the family in the modern sense of a parent and his children, but the wider kindred of the gweli, or the group of related gwelis headed by the chieftain who provided the da. The constitution and working of the gweli. Now, as the gweli was the unit of land occupation, it is worthwhile to try to realize a little further what it was and how it worked. Viewed in its simplest and perhaps original form, it was a family group of 4 generations, the landed rights of which were vested in the great-grandfather as its chieftain. The tribesman, his descendants, had only rights of maintenance. By right of kin and descent, they had received their da from the chieftain. The flocks and herds of the chieftain were the common stock out of which the da had been given, and there is reason to believe that under earlier custom, on the death of a tribesman, his da went back into the common stock of the chieftain. At the date of the codes, it did so when the tribesman died without issue. But in the codes, a peculium of private property, of which the da was the kernel, is recognized and allowed to descend to a tribesman's children instead of falling into the common stock. When the great-grandfather died, the chieftainship, with the landed rights and the herds, was divided between his sons, who as brothers thus became chiefs of sub-gwelis. But the original gweli did not then break up, because there would be a right of division per capita when the brothers were dead between first cousins, and when the first cousins were dead between second cousins. The division between brothers was probably originally made only between those sons of the parent who were living at his death. Like the sons of the surviving brothers, the sons of a deceased brother must be content with their da till all the brothers were dead, and in the division between first cousins they would take their share per capita along with the rest. But at the time of the codes, by what continental examples lead us to regard as an innovation, the orphaned nephews were allowed in the division to succeed at once, side by side with their uncles, to the share and position which their father would have taken had he survived. Even after this innovation, if a brother had died without issue, his brothers, as brothers, did not at once succeed as co-heirs. The share fell into the common stock till a division, and then went to all the co-inheritors per capita, so that cousins, and it might be even second cousins, took their shares in it. The introduction of succession by representation to a deceased father's property and privilege was, as we shall see in continental cases, a step taken in the direction of individual ownership. It complicated the matter of the division or devolution of the chieftainship in the gweli, but it is a point of interest in connection with the continental evidence. A clear understanding of the constitution and working of the gweli as a typical family group is so important to this inquiry that it is worthwhile to place before the reader the passages in codes upon which, taken together with the surveys, the foregoing description of it rests. The following is the clause in the Venedotian Code describing what took place in the gweli, under the heading, The Law of Brothers for Land. Quote, "Thus, brothers are to share land between them, 4 erus to every tithin, that is homestead. Blethyn, son of Cynfyn, ultidit to 12 erus to the uchelor, and 8 to the aellt, and 4 to the gadog, yet nevertheless it is most usual that 4 erus be in the tithin. If there be no buildings on the land, the youngest son is to divide all the patrimony, treu itat, and the eldest is to choose, and each in seniority choose unto the youngest. If there be buildings, the youngest brother but one is to divide the tithins, for in that case he is the meter, and the youngest to have his choice of the tithins. And after that he is to divide all the patrimony, and by seniority they are to choose unto the youngest, and that division is to continue during the lives of the brothers. And after the brothers are dead, the first cousins are to equalize if they will it, and thus they are to do. The heir of the youngest brother is to equalize, and the heir of the eldest brother is to choose, and so by seniority unto the youngest, and that distribution is to continue between them during their lives. And if second cousins should dislike the distribution which took place between their parents, they also may co-equate in the same manner as the first cousins, and after that division no one is either to distribute or to co-equate. Tir Gweliok is to be treated as we have above stated. End quote. In the Dionysian Code, the same rules of division are stated as follows. Quote, when brothers share their patrimony, trev oitat, between them, the youngest is to have the principal tithen, and all the buildings of his father, and 8 erus of land, his boiler, his fuel hatchet, and his coulter, because a father cannot give those 3 to any but the youngest son, and though they should be pledged, they never become forfeited. Then let every brother take a homestead, Isidon, with 8 erus of land, and the youngest son is to share, and they are to choose in succession from the eldest to the youngest. 3 times shall the same patrimony be shared between 3 grades of a kindred, first between brothers, the second time between cousins, the third time between second cousins. After that there is no appropriate share of land. After there shall have been a sharing of land, acquiesced in by co-inheritors, no one of them has a claim on the share of the other, he having issue, except for a sub-share when the time for that shall arrive. Yet whosoever shall not have issue of his body, his co-inheritors within the 3 degrees of kin from the stock are to be his heirs. End quote. Only by adhering very closely to these texts can the Gweli be understood. They seem at first sight to refer to the tithens or homesteads, but as we have seen, the landed rights of grazing in the villetae in which the Gwelis were located were included also. It would obviously be a fair critical question to ask, what happened when the second cousins at last broke up the Gweli of their grandfather and divided the land, or let us say the homesteads and the tribal rights of grazing on the land, for the last time equally per capita? There might be 20 or 30 of such second cousins. Did the original Gweli split up into 20 or 30 new Gwelis? Let us try to realize what happened by carefully following the text in the light of the Denbigh survey. Let us take a hypothetical case in which the Gweli of X is described by the surveyor as holding an undivided share of the rights of pasture, etc., in a particular villata or in several villatae, and assume that, according to the record, the internal divisions of the Gweli followed the family division of the descendants of X as in the following table. Then, applying the rules of the clauses as to Tir Gweliawk, let us see how it would work out in the hypothetical case stated. The text shows a table set out as a family tree. At the top, we have X, great-grandfather deceased. He gives issue to son A and son B. Son A gives issue to grandson AA and grandson AB. Grandson AA gives issue to great-grandson AAA. Grandson AB gives issue to great-grandson ABA and ABB. Son B gives issue to grandson BA, BB, and BC. Grandson BA gives issue to great-grandsons BAA and BAB. Grandson BB gives issue to great-grandsons BBA, BBB, and BBC. Grandson BC gives issue to great-grandson BCA. End of table. Now let us suppose that X, the great-grandfather from whom the Gweli is called the Gweli of X, is dead. While his sons A and B are alive, they share equally in the grazing and other rights. When A is dead, and so long as B is alive, no change is made except that A's 2 sons share equally their father's right to which, in the phrase of the codes, they have ascended. B at length dies. There are 5 grandsons, first cousins, who have a right to share in the rights of the gweli of X per capita. There is now therefore a rearrangement, after which A's sons share and hold jointly only 2/5, while B's 3 sons hold jointly 3/5. Equality per capita among grandsons has now been effected, but the gweli goes on. It cannot be broken up because in another generation the great-grandsons may require a fresh division. Next, let us see what happens when all the grandsons are dead and the final division per capita takes place. There are 9 great-grandsons. Is the gweli of X now to be divided into 9 new gwelis? Certainly not. The grandsons of A are entitled to 3/9 only, and this they divide per capita, being first cousins. One family takes 1/3 and the other 2/3. The portion which has fallen to them of family rights in the gweli of X has become a separate gweli, called either the gweli of A, or as we sometimes find in the Denbigh survey, the gweli of the grandsons of A, that is, gweli weirion A. The other portion has become either the gweli of B, or the gweli of the grandsons of B, that is, gweli weirion B. The grandsons of B, being first cousins, have of course redivided their 6/9 equally per capita, and the internal rights of the gweli of the grandsons of B are: grandson BA's 2 children have 2/6, grandson BB's 3 children have 3/6, and grandson BC's 1 son has 1/6, comprising 6/9 in total. They cannot break up the gweli of the grandsons of B because they are not second cousins, but when all of them are dead, their children will be second cousins and may do so, and then 3 new gwelis will be formed in the same way as above, and so on forever. The process is continuous and always within the same rules of Tir Gweliog. This seems to be the state of things as regards succession within the gweli, resulting from the rules laid down in the codes and found at work by the surveyors of the Lordship of the Honour of Denbigh. But we must remember that, apart from these rights of succession, each tribesman on becoming a tribesman had been the recipient of his dar, and so had had cattle of his own all along in the common herd. Finally, the position of females in the gweli should not pass without recognition. They are not mentioned in the statements of landed rights, because, provision having been made for their maintenance independently of their father, they were assumed, whilst claiming their gwaddol, or portion, to take this with them on marriage out of the gweli. They ought to be married into another gweli, within which their sons in due course would receive inheritance and landed rights by paternity. Only on failure of this could their sons claim landed rights by maternity in their mother's original gweli. The liability of the wider kindred for galanas in case of homicide. Such being the gweli, we pass on to the wider kindred, embracing the descendants of 7, and for some purposes 9, generations from a common ancestor. We find from the Cymric codes that the members of the wider kindred had common responsibilities in case of homicide causing a blood feud between kindreds. A murder within this wider kindred was regarded as a family matter. The murderer was too near of blood to be slain. No atonement could be made for so unnatural a crime. There was no blood fine, or galanas, within the kindred. The murderer must be exiled. But a murder of a member of one kindred by the member of another, inasmuch as, if unatoned for, it would under tribal custom have produced a blood feud between the 2 kindreds, was the proper subject for the substituted payment of the blood fine, or galanas. The galanas was thus a payment from one kindred to another in lieu of the blood feud, but its amount was divided in payment on one side and in distribution on the other, in varying proportion, according to nearness of relationship to the murderer or the murdered person as the case might be. And in these payments and receipts, all the individual tribesmen within the kindred who had received their dar must take their share if needful. The question who had to pay and who had to receive was moreover complicated further by the fact that it involved maternal relations as well as paternal relations. It has been very properly pointed out that however it might be as regards money payments, it is difficult to conceive how the liability of maternal relations could be worked in the case of actual blood feud and fighting. A man might have to fight for his maternal relations against his paternal relations, or the reverse. In such a case, what must he do? How should he act? He might be in an impossible position. Light upon this point and others may be obtained, perhaps, when the evidence of Beowulf is analysed. This evidence will show that a man may have good cause under tribal custom not to join in some feuds. And further it will remind us that feuds often arose in contravention of tribal usage, breaking the peace which in theory the link of marriage ought to have secured. In the meantime, it would seem impossible that the custom of a tribe might, for anything we know, forbid marriage within the near relationships of the Gweli, and beyond the limits of the wider kindred. In such a case, paternal and maternal relations might all be within the kindred, so that, properly speaking, a quarrel between them could not become the subject of a feud. In such matters, it is obvious that a good deal must depend upon the view taken of marriage itself at the particular stage of evolution in which the society might be. And it may as well be said at once that we should be quite wrong were we to regard marriage from the Roman point of view, i.e. as a transfer of the woman out of the potestas of her parents into the potestas of the husband. The Cymric example, to begin with, was quite different. The marriage of sisters to tribesmen from whom their sons could inherit tribal rights was a duty cast upon the kinsmen of the Gweli. Footnote: if the sister was married to an Ashtid and her son killed a person, 2/3 of the galanas fell on the mother's kindred, but there was no liability beyond the Gweli or second cousins. End of footnote. It was thus an arrangement between two Gwelis, a link between them, but no transfer. If a wife was slain, her galanas or death fine did not go to the husband and his family, it went to her kindred. If a wife should commit murder, it was the wife's family, and not the husband's, on which rested the payment of galanas for her crime. Footnote: 3 cases wherein a wife is to answer without her husband. The first is for homicide. But for accessories to murder, she and her husband pay her camleru and derui, and she can claim spear penny. End of footnote. If the husband were killed, the wife took 1/3 of the sarad, or fine, for insult and wounding, but she took no part of the galanas of her husband. Footnote: on separation, husband and wife divided the cattle and most other things equally. End of footnote. These points are, in a sense, unexpected. They belong to a stage of social life as far removed from Roman rules, or modern ones, as they are from the stage in which a wife was either purchased outright or stolen. And yet we shall find them in principle more or less clearly repeated in the varying customs of some of the tribes whose laws we are about to examine. End of section 3.